I also grew up out here too. I grew up in Coger, which is about 25, 30 miles southwest of here, out in the middle of nowhere. But that's a little bit about me. What I'm going to be talking about today is whenever you talk about the law, you basically got two parts of law. You got criminal law and you got civil law. We're only going to be dealing with the civil law. There's nothing about criminals today for this kind of stuff. When you get into the civil law, it breaks up into two halves again. You got contracts, and then you got torts. And the definition of a tort is basically every other civil thing out there besides contract. So I'm going to kind of be talking about the torts. Shannon's going to be talking about the contracts, such as the wind leasing contracts that people are going to approach you about to sign to put up one of these turbines. So I'm going to talk about some of the other legal issues and some of the impacts, things like environmental law, nuisance claims, that kind of stuff. And then Shannon's going to be getting into more of the contract issues themselves. If you've got any questions, though, that come up while I'm talking, go ahead, raise your hand, wave it, whatever it takes to get my attention. Whenever you're dealing with these legal topics, if a question pops into your mind, a lot of times it's better to ask it right then when it's fresh on your mind than it is to try to remember it to the end. And it doesn't bother me at all if you want to stop and ask a question. I could start, stop, go on. After a while, after doing enough public presentations, you just get to the point where it's kind of nice to have people break up your talking by asking questions. So please feel free to ask any questions as they come up. If I can't answer them, I'll probably throw Kyla or Mike under the bus. So, all right, that's what I'm, get your coffee, be ready. Like Shannon said, what I do, both my wife and I work at the National Agricultural Law Center. Basically what we do Shannon Farrell's job for the entire country. Most states out there aren't lucky enough to have an attorney that's dedicated just to legal issues in extension for their state. Oklahoma is one of about 8 or 9 that actually has an attorney in that position that helps on that with this kind of matters. So it's really nice to be able to work with Shannon on this kind of stuff. We try to cover a lot of ground, but we can't be experts in everything. Shannon is really good when it comes to the wind development issues. So I'll probably throw him under the bus too if there's certain questions I can't answer. But basically what we do, we're a federally funded institution. We are not bipartisan, we are nonpartisan. You call us, you send us an email, we try to get back to you with an answer. We don't give legal advice. Like I said, we cover the entire country. We're not licensed to practice all over the country. I am licensed in Oklahoma, but I still try not to give legal advice because I don't have malpractice insurance at the moment. So in case I told you something wrong, I don't want you suing me. Our job, though, we provide this legal research and information to farmers, to consumers, and we work a lot with state and federal policymakers. So we work with everybody. We get questions from all different types of topics. Most of our stuff, though, is done through our homepage here at the Ag Law Center. And if you go to this site, we've got free legal information covering just about every topic you can think of that relates to agricultural law. We have things divided up by topic. We cover everything from water law to environmental law. If you want to know about farm program payments, we've got that information. The same type of stuff that the county officers in the FSA office use when they're answering your questions. So you can actually look this stuff up on your own and verify it. Really handy tool. Now, that stuff we have on the farm program payments may be changing dramatically here in the next little bit, depending on if we get a farm bill coming out or not, but we've still got it up there. But just about everything you can think of that relates to agricultural law, we're going to have information on it. The really beneficial point to this information is this is stuff that you can look up on your own, kind of get an idea about the subject matter and the topics before you need to go talk to a lawyer. Let's take estate planning, for example. You can go to a lawyer and you can get the estate planning process explained to you in great detail. And while that lawyer's doing it, guess what? He's charging you to learn all this stuff. You can go here, learn the basics, and when it's time to go in there, you save yourself a lot of money on the front end by not having to listen to that lawyer explain the basics to you and charge you 100, 150 bucks an hour to do it. So that's kind of what we do with our center, and we do a lot of outreach across the country. Each of these reading rooms are divided up the exact same. So if you go to one, you understand the format for the rest of them. We deal with a wide variety of people. So even though we're dealing with legal topics, most of our stuff is written so that it's beneficial to farmers and ranchers. There's certain things that are geared more towards attorneys, such as the case law and some of the things on the regulations, but the same stuff that's available for government regulators is available for the private parties. So it's a very beneficial resource. I hope people out there are able to use it, and if you can't find anything on there, please feel free to contact us. We'll do what we can to help you out. That's kind of my little spiel about the center. It can last 5 minutes, 15 minutes, or it can go on for an hour. Anymore, most people don't ask for the hour one, but I wonder why. But the things I'm going to be talking about today, like I said earlier, I'm going to be looking at the things primarily other than the contract. But I'll keep referring back to the contract, and there's a reason for that. Anytime you're dealing with the law, specifically with civil law, a contract can change things a lot. I might tell you, well, this is the way the law goes in this case, unless you say otherwise in a contract. And if you have a question about that, ask when we're going through it, and I'll kind of explain some of those different aspects. But a contract can actually change a lot of this stuff. Well, can I sue this person? Well, if you signed a contract saying that you won't sue this person, you kind of can't sue that person. I mean, barring some different circumstances. So, I mean, there's a lot of things like that. It can really change the situation. So, if you've got a question, ask. I'll probably throw out, well, it depends on this and it depends on that. The fact of the matter is, I'm not just trying to waffle on it. A lot of things matter whenever you're dealing with the legal stuff. So, if you got a question, I'll try to answer it the best I can. I may not be able to give you the exact answer you're looking for, though. Like I said, I'm going to be talking about some of the impacts to landowners, and I'm going to be talking about some of the environmental impacts from the wind leasing projects. I'll talk a little bit about the community development aspects at first. Kyla threw up some great numbers from the Keenan 2 project, you know, the tax revenue and the community impacts that are created through the development of these projects. It's really hard to give numbers on these, though, because guess what? Every community out there is going to be different. Every wind project is going to be different. So the impact that they have is going to vary widely depending upon what you've got. Last couple of years, they've been putting up the wind farm for the Minko project. Well, one of the big money makers for a town is, you know, you got all these construction workers living in the area, renting hotel rooms and the like. When I was up in Woodward, I was staying at a Motel 8, paying almost $100 a night at a Motel 8. These people are the motel owners up there are making money hand over fist because of all the developers coming in here. What do you think the motels in Minko, Oklahoma are making right now? I grew up in Minko. Let me tell you, there's never been a hotel there as long as I can remember. So, I mean, they're not getting any of that development aspect from people staying in town. So, like, yeah, or Koger. I can tell you right now, there's nothing out there at Koger. My parents' house is out there. I mean, if you guys want to have a room out there, they're the ones to ask. Mine's empty at the moment. So I mean, it's going to vary depending upon where you're at. So numbers for one area is not going to match up with numbers from another area. But there can be some really good beneficial consequences from the money that's flowing in. I think Minko's right now is building a new high school. God knows they needed it. I went to the old high school they've got. So I mean, there are positive economic consequences that flow from it, but it's always going to vary depending upon the facts and circumstances. Everything's going to be unique. Every project out there is unique. I'm also going to talk about some of the other legal consequences, some of the other legal circumstances that surround it. Things like nuisance lawsuits and view shed issues, noise pollution, that kind of stuff. what can be done about that, what's kind of happened in the past, what are some of the options. And then finally, I'm going to talk about some of the environmental issues. And I'm mainly just going to focus on the Endangered Species Act, because that's typically the one that gets people in trouble. Whenever you see an environmental issue coming up with a wind development project, it's typically under the Endangered Species Act. You kind of know how to get around the Clean Water Act. You know the permits you got to request and things like that. It's not as easy to work around the Endangered Species Act. Not only is it important for wind development, though, it's also important to landowners. Because this is a type of statute, it doesn't just impact the wind developers or the oil and gas industry, it also impacts the landowners and what they can do with their property. So that's the reason why I kind of bring in the Endangered Species Act too. So like I said earlier, what I'm trying to do is, Shannon's going to be addressing the contract part of civil law, I'm going to be doing the tort part. A tort is basically a civil wrong. It's either an act or an omission to act causing by one person that causes harm to another one. That's all it is. You've either done something or you failed to do something, and because you did that, someone else is injured. And you can sue for it in a court of law and get damages. Whether it's monetary damages or some kind of injunction to get people to stop doing what they're going to do in the future. These types of laws have been around for hundreds of years. Part of the old common law. We brought it with us over from England whenever we settled the New World. There's nothing new about this stuff. There is some things that are a little bit different, though, as it's applied to wind, just because, guess what? This is a fairly new industry. Oil and gas, we've had that in Oklahoma since statehood. Wind industry, though, I mean, we're talking, this is brand new. Or at least brand new according to the law. Anything that's less than like 100 years old is brand new to the law. Most of law is very old. So that's a little bit about what the torts is, and as we're going through them, I'll talk about some of the torts and some of the problems that people have been having, either suing under them or some of the issues with them. Whenever you're looking at the wind projects, there's certain things that you have to look at as saying, well, these are potential legal issues that they may face. Either the developer may face or the landowner may face. And the contract that's entered into is actually going to play a huge role in this type of litigation issues. The things I'm going to be talking about, the shadow flicker. Does everyone in here know what I'm talking about when I talk about shadow flicker? If not, take a look up at the light and then start doing this right here while you're staring into the light. That's what I'm talking about by shadow flicker. You do that long enough, you'll get a headache. But that's one of the issues. Aesthetics is another one. The view shed. You know, you're changing the way the countryside looks. We actually get calls on that right now. One of them I'm getting on the aesthetics is from California, and I'll talk a little bit more about that in a second. And some of the other tort claims. Ice throw, blade shear, potential fire risk, and roaming livestock issues are all things that need to be thought of whenever you're entering into the wind leases. Ice throw is the ice that can accumulate on a blade, and then when it starts back up, the revolutions per minute are fairly slow on most of these turbines, 100 or 21 revolutions per minute. But if you actually go out there and measure the speed, the miles per hour on the tip of those the ends of the blade, you're actually getting some pretty decent velocity, 150, 200 miles an hour. If you got a pretty good chunk of ice out there on the end of the blade and it gets hurled off at 150, 200 miles an hour, I'd hate to be hit with that. I mean, it can cause some damage. Blade shear, what happens if a blade falls off? That hasn't been an issue as much lately. Like I said, the wind industry is fairly new. If you take a look at one of the chapters, it has the number of wind turbine accidents by state. Earlier, Kyla was telling you, certain states have got a lot more power than others. California's got a huge number of incidents compared to other states. 25 accidents over a 4-year period. California really doesn't produce that much electricity, though, but they were one of the first states that put in the wind turbines. Texas, on the other hand, produces a lot of wind energy, and they're down there at like 6 incidents over a 5-year period. It's this differences in technology. As time goes on, they get better at making these wind turbines. They're less dangerous, they're more efficient, they're cheaper to put up. I mean, they're getting better at doing it. So like the rate of accidents is actually decreasing with the newer technology. Fire and roaming livestock, we'll talk a little bit about that too as we get to that section. Some of the issues you might need to be thinking about as a landowner. One of the main causes that we typically see with the wind farms is nuisance actions. A nuisance action is basically a substantial and ongoing interference with a landowner's use and enjoyment of their property. Sounds fairly simple. We're only going to be talking about the private nuisance. Public nuisance is like if a city is suing somebody for an ongoing nuisance. None of these projects are located very near to towns, like Kyla was talking about. K-Met's probably going to be about as close to Oklahoma City as these things get for a while. I mean, they do better out in the open where it's flat ground, wind's unimpeded, so you're not going to be dealing with towns. So it's almost always going to be a private nuisance action. One party, one landowner going against a developer, or maybe two landowners going against a developer. It covers a wide range of things though. Shadow flicker might be considered a nuisance. Noise, odors, dust, flies, all the things that you're familiar with from agricultural operations. We get calls at this kind of stuff from the center all the time. Not just related to wind, but to agricultural practices. You know, hey, some farmer's out here disting up his land at 7 a.m. on a Sunday morning and destroying my peace and quiet. What can I do about this? Or so-and-so's putting in a hog operation and it's a mile away, but I can still smell it. What do I do about this? Nuisance litigation is one of these things all farmers have to worry about. When you're dealing with the wind, though, I mean, you're basically dealing with noise and light. They don't put off a whole lot of odor. Flies really aren't an issue, but they are more of an issue for the normal types of ag operations. Whenever you're looking at these nuisance operations or nuisance lawsuits, they're fairly simple to talk about, but when it comes time to proving them and going out there and winning a lawsuit, they're a little bit more difficult to do. First of all, you have to have some kind of fault. That's typically fairly easy to show. Somebody did something, and because they did that, they caused you harm. Typically it's an annoyance whenever you're dealing with nuisance. They're doing something that's annoying you and devaluing your use of your land. Or maybe even devaluing the value of your land, depending on what you're wanting to do with it. So someone's got to be at fault. The second thing is, it's got to be substantial and ongoing. You don't get to just go against your neighbor and say, you know, well, they threw a 50th birthday party for a parent and they got kind of rowdy that night and we want to sue them to prevent this again. Well, guess what? How many times did your parent turn 50 years old? Once. Unless it's your mother, she might turn 50, 4 or 5 times. But for the most part, it's a one and done type occurrence. If that's the case, is that substantial and ongoing? No. What about a wind turbine, though? When Shannon talks about these leases, the length of these leases can vary dramatically. Some of these leases might be 25, 30 years to begin with 2 additional options to renew, which might extend it to 50, 60 years. Some of these leases have been up to 150 years long. Not many of the recent ones. Shannon will talk a bit more about that. Not many of the recent ones have been 150 years, but there were some of the earlier leases that were signed that were 150 years old. I don't know if Mike mentioned this, but if Robert E. Lee, when he signed his surrender at Appomattox Courthouse, if he would have signed one of these wind leases, it would still be in effect to this day. So, I mean, could you say that's a substantial and ongoing one? Absolutely. I mean, you probably wouldn't live to the end to see the end of it. So, I mean, when you're dealing with the wind industry stuff, this is another element it's pretty easy to meet. Once they invest the millions of dollars to put one of these things in there, they're not going to take it down. So, the ongoing aspect's easy to find too. The problem, though, with this type of litigation is this last element, and it's the reasonableness aspect. All they're talking about when they're talking about reasonableness is basically a balancing test. Is the utility from the action that's causing this nuisance, does it outweigh the harm that it causes? If it outweighs the harm that it causes, they're going to say, you know, you just need to live with it. If it doesn't outweigh the harm that it causes, you can win the lawsuit. But it's the balancing test that kind of throws people for a loop. Does the gravity of the harm outweigh the social value? And when you look at these cases, it kind of depends on, well, what's the social value of what's going on? If your neighbor opens up a nightclub right next to your house and they're playing music until 3 a.m., the social value of that neighbor opening up the nightclub, it's not that high, is it? At least you're probably not going to think it's that high. What about putting in a wind project, though? How much do you think these things cost? Mike just talked about a while ago, if you're switching out a gearbox on one of these turbines, it's a $500,000 process just to swap out a faulty gearbox for a new gearbox. These things are multi-million-dollar projects, hundreds of millions of dollars. There hasn't been a whole lot of successful nuisance litigation against wind farms because of this. You're living on a quarter section of land, your neighbor's got wind turbines on his land. How much is your quarter section of land worth? Right now, land prices are pretty high. $500,000. Say land prices are really high. On the other hand, you've got a $250 million wind project. $250 million on one hand, $500,000 on another hand. For this reason right here, we haven't seen a whole lot of successful nuisance litigation against any of the wind farm projects. Another reason, yep.
For instance, if you own a farm.
Yep.
And except maybe a couple of acres that you have sold to someone who owns a home.
Yep.
On that. And then they are unhappy if a wind farm goes in on your farm around them. Would they be suing the landowner who had made this lease agreement with the wind company, or would they be suing the wind company or everybody involved?
Typically, and this is the good answer, that's a great question. As a lawyer, my answer is you sue everybody. I mean, but really and truly though, what you're wanting to do in that case is you're wanting to get money. Who's got the money? Do you sue a farmer or do you sue a company that's got a multi-million-dollar wind project? Most farmers, they're asset rich and cash poor. What's the old saying? You don't get blood from a stone, and you can't hardly get money from a farmer. So, I mean, they really want to go after the wind developer. The farmer, on the other hand, and the other thing is, they're also your neighbor. If you sue your neighbor, you're not going to have the best relationship going forward. And chances are you're both going to be right there for the foreseeable future. Some of the worst fights you'll ever see is one neighbor against another neighbor. Anytime anyone's getting sued out there, you generally look for two causes. One, it's a neighbor that you've angered in some way. And the second one is it's a competitor. That's the two people that will generally get you in trouble. If you're doing a business and you've got a competitor out there and they can turn you in for something or sue you for something, they'll do it. The other thing is that neighbor that's mad at you. And that covers a whole wide variety of issues, not just wind, environmental cases. How many times do you see someone out there from NRCS or EPA out there driving around looking at people's land? Not very often. But if you make your neighbor mad and your neighbor calls EPA and turns you in saying, well, they're discharging pollution right into the stream. I can see it running into the ditch. That's when EPA will show up and go after you. So.
Also, in that instance, the person who owns this 2 acres of surface right for that, they would also have to be involved in the wind lease agreement?
They may not. It's not going to be on their property.
No. Okay. All right.
It depends on the developer, though. I mean, some of the developers out there will go ahead and they're going to pay the surrounding landowners a little bit. Mike talked a little bit about it earlier. Now, do they get as much money? No, they wouldn't get as much money because they're not going to have a turbine and roads and that kind of stuff put on their property. But some of them will pay. Others don't. So it really depends on the developer. So, I mean, it's depending on where you're at and who you're dealing with. Some might not. Like I said, it's this reasonableness aspect that's kind of been the kicker whenever you're dealing with the nuisance litigation. Multi-million-dollar project on one hand, farm that's worth $500,000 on the other. It's been a real difficult hurdle to get over. Some of the other factors that kind of come into play, because there's always more than just 3 elements to get into anything. Things like, they haven't greatly improved the quality and safety of a lot of these turbines over the years. You see some of those early turbines in California and some of the modern ones that they're putting in Texas, Oklahoma, other states like that. There's a huge difference between them, New braking systems, things like that have made, they're trying to reduce safety defects, and they're trying to do other things like limit the noise. So some of these later turbines, the noise generated from it may not be very much at all. So that may not be an issue with what you're dealing with. Can you eliminate everything? No, it's impossible. You can't ever make anything that's, completely noiseless or 100% safe. But these steps that they try to take to limit this stuff also come in on the lawsuit side saying, hey, listen, we're trying to be reasonable. We're trying to do things to the best technological level that we got. They also look at other things. Well, what's the setback limit? How close are we putting these to the property lines? If you sign one of these wind leases, a lot of them will have things like, you're accepting the shadow flicker or the noise, or if something like ice throw happens, that's part of the lease. Now, if the neighbor next to you didn't sign, that might be an issue for them. But a lot of times they'll do setback requirements just like you got with oil and gas wells. You got to keep it so far away from the property line. Different states require different things. There was a case in Pennsylvania that said, well, ice throw might be an issue. But you get someone that knows a little bit about physics, they can go out there and they can calculate the height of the tower and how fast the blade's traveling, and they can actually figure how far this thing could throw a piece of ice. So you say, okay, if this thing can throw a piece of ice, pick a number. 1,000 foot, you got to put the tower back 1,100 foot. Now, do you have to worry about getting ice thrown onto your land? Probably not. I mean, the ice that it could land on, this person signed a contract, and depending upon what's in the contract, they may be able to recover for it, they may not. It all depends on what's in the contract. And that's an example of the shadow flicker and the setback. They actually do go out there and calculate that stuff. Not only is the spacing of these turbines set up to maximize the wind energy that they can to accumulate, they're also going out there and looking at the legal aspects. We don't want to get this too close to neighbors' property that might not have signed up. So they're looking at all this stuff plus a whole lot more whenever they're doing one of these projects. These things are extremely complicated once you start looking at details. Here's an example. This is just mainly for the generation, but you can see they're very meticulous in how these things are actually located. A lot of time and effort goes into planning where these turbines are going to be placed. Like I said, not just for capturing the wind, but also for the legal aspects. So I got an example here. For me, it's always fun to work through examples. You got Ted, and Ted's a landowner. He lives near a wind project, and he's suing the developer under nuisance because of shadow flicker. What can happen? Well, depending on the lease, if Ted signed the lease, maybe nothing. because he may have signed away his rights to litigate under nuisance. So the first question when you're dealing with any of this is, what does the contract say? Before you sign any contract, wind, land lease, oil and gas, always read the contract carefully. And I'm sure Shannon's going to get into this much more deeply, but when you're dealing with these types of projects, the consequences can go on for a long time. You know, the old saying, learn from your mistakes. Well, some of these leases, like an oil and gas lease or a wind lease, they can actually go on for so long, you may never get a second shot at it. So then the saying, you know, learn from the mistakes of others because you're never going to live long enough to make them all yourself, kind of comes into play. So these are areas where it's really nice to read the contract carefully and to have a licensed attorney that's familiar with the industry to be able to go in there and say, you know, okay, this is what it says, here's some of the issues. Because you can sign away some of these rights in a contract and never even realize you did it until later on. If Ted didn't sign a contract, then you work your way through those elements of nuisance. Was someone at fault? Usually pretty easy to prove. Was it substantial and ongoing? With wind, that's pretty easy to prove. And then finally, that reasonableness aspect, that balancing test. That reasonableness is where the problem's been showing up as far as the nuisance litigation. Not a whole lot out there. Aesthetics is another one. You know, the view shed. Some people love the way the wind looks. They look out there and say, hey, that's green energy right there going. Looks beautiful. Neighbor across the road who may not have gotten a turbine on their land, I mean, they're saying, you know, looks awful. It all depends upon your view, your particular your point of view. I actually gotten calls out of California. People are wanting to do agritourism operations. You guys ever heard of those? People will actually show up at your farm and pay you money to do your chores. They've never fed a bottle calf before. They've never rode a tractor before. People will show up out there and pay them good money to do things like that. Part of it is, you know, that experience of being out in the countryside. Well, they're arguing, you know, we've got this business, people paying us to do our chores, and it kind of detracts having this windmill in the background because, you know, they're coming out there to the wide open to be out in the country, and it doesn't quite feel like the wide open anymore when they see these wind turbines surrounding them. So these people are wanting to sue, and they actually make a lot of money bringing in people to do their chores for them. And they haven't had a whole lot of success in this, though. People generally aren't going to be very good at this, and there's that old saying that kind of proves true. Beauty's in the eye of the beholder. One landowner that's got 3 turbines on his property might be thinking they're the most beautiful thing ever, especially when that check comes in. Guy across the fence row that doesn't have any turbines, it may be a completely different situation for him. So in cases like this, courts generally don't like getting involved. They're not artists. They're not going out there and saying, you know, well, this attracts from the beauty of the land or this detracts from the beauty of the land. Courts don't want to get involved in that kind of stuff. If they can't assign a number to it, they typically don't like messing with it. So this has been another one of those areas. It just hasn't worked out very well for people that have brought suits under this stuff. Now, if they did something like do a wind development project out around the rim of the Grand Canyon, that might be something where it might be a bit more of an issue. But so far, where the wind projects have been located, aesthetics has not been an issue. There are some other causes of action that you're a lot more likely to be successful at bringing a suit. One of them is trespass. Trespass is pretty easy to do. A lot of people out here can trespass and never even know it. It's a direct physical invasion of another person's property. That's it. There's no other elements. If this right here is the property line onto my neighbor's property, and one night I'm wandering and I put 1 foot over on it, I've trespassed. No ifs, ands, or buts about it. I don't get to make an excuse. I can't say, you know, hey, I was lost, or I thought that was still on my side of the land, or nothing. That's it. Once you've trespassed, you've committed the tort, you're liable for damages. What's the problem with that, though? What was my damages that I just did? I put 1 boot on the other side of the land. Well, I trampled down a few blades of grass. That's the problem with the trespass. It's really easy to prove, but there's no real money involved unless some kind of damages occurs. Things like the ice throw or the blade shear. You chunk a piece of ice onto someone else's land and you injure a cow, or you got a $250,000 combine there and it hits it, then you've got damages. You got real damages. There's not a lot of cases out there on this type of stuff, though. And there's some reasons for it. How many cases, if you guys had to take a guess, how many cases end up in a verdict? If I sued you or you sued me, how many cases do you think are going to go all the way to getting a verdict, either from a judge or jury? About 3%. Most cases never make it all the way through the judicial system. What happens, you got 2 lawyers on on each side, they both look at the issue, and one of the lawyers realizes pretty early on, oh crap, I'm going to lose this one. So you settle. You know, hey, I'll pay you money right now. You're asking for $100,000. I might be willing to pay you $70,000 right now, and you don't have to fight it out. We can just end it right now. So a lot of cases settle and never make it through the court system, and they never become law. And it's just because, well, we see right now this thing's going to end, and we're not going to be the winner, so let's try to get out of it early and cheap. The situations where you don't see that, though, remember those neighbors that don't like each other very well? Those are the cases that actually make it into the legal system. One neighbor suing another neighbor, and they might win $1. But it wasn't about the money. It was about the principle of the matter. You know, I beat him. It might have taken me 5 years going through the court system and $40,000 in attorney's fees, but by golly, I beat him. That's another reason why you don't want to make your neighbors mad. That kind of stuff can happen. So, I mean, you don't see a lot of case law dealing with this kind of stuff. If something like that happens, if a piece of ice gets thrown onto your land, and it injures or kills a cow, chances are they're going to pay off that. It's fairly cheap. I mean, even with cattle prices what they are now, it's still cheaper to buy that cow than it would be to litigate this out. So you're not going to see a whole lot of case law out there dealing with it. These are the type of issues, they get settled early on and they're gone. So there's no actual way to tell, well, how many people out there are suing for this kind of stuff? You don't know. It doesn't get reported. The only time it ever gets reported is if you get a final judgment for a case. And like I said, only about 3% of those ever make their way all the way through. Makes it tough for lawyers, especially trying to figure out what all is going on. Negligence is another cause of action, and it's something that landowners need to be aware of. Whenever they go out there and they're putting turbines up on the land, guess what? There's a lot of trucks going in and out. It takes a lot of loads of concrete just to form the base for one of these turbines going in and out. Unbelievable amount of traffic. Well, if you've got cattle on your place, guess what? You don't want your cattle out in the road. What happens when cattle get out in the road? They get hit by vehicles. When someone hits one of your cows, guess what? They're not very happy. They're liable to sue you for the damages done to their car. They may not even care about the fact they killed your cow. They're generally pretty ticked off about the damages done to their car. Well, who's going to be paying for that? It's your cow. It's something, though, that you can address in the contract. Say, hey, I realize there's going to be a lot of traffic going in and out. That's fine. But I got cattle on this place. Put a cattle guard in. Do something. We just don't need cattle out there roaming at large. There's a lot of other issues that can come up depending upon what kind of operation you've got, how many people you've got going by. Everyone's farming operation is going to be a little bit different. Some of the things that you might be worried about might be things that no one else is worried about. I'll give you an example. My family, my dad used to fly a spray plane. So an issue for him might have been, you know, hey, a wind lease might be fine, but I don't want any turbines close enough that's going to impede that little grass runway that I got for taking off and landing. That might be a little bit of a problem. Is anyone else going to have to worry about that issue? No, probably not. But it's just a unique fact or circumstance that affected him directly. Everyone's going to have that little bit different thing because guess what? Your land and your operation is different from everybody else's out there. So you need to be thinking about these kind of things when you're going into the negotiations on a contract. Whenever you're dealing with torts, if you can win the lawsuit, you either get one of two things. You get money, or you try to get the person to stop whatever action they're doing that's harming you. Generally, courts like to give money. They don't like forcing people to do things. You know the old saying, money cures all ills? That's kind of the way the court system works. If they can give money to fix something, they'll do it. There's some things out there that money it doesn't fix. It's too hard to value and things like that. In that case, the courts can grant injunctions. Basically like a cease and desist order. You know, you stop doing whatever you're doing that's causing the nuisance or caused the negligence. You need to knock it off. You're not seeing a lot of these injunctions, though, with the wind projects. I mean, they're multi-million-dollar projects. They're not going to go out there and say, you know, we know you've invested $100 million into this. You need to stop because of this reason. Court's typically not going to do this. It's easier to pay the damages to the landowner. There are a few situations where they went in there and granted injunctions. And one of them I'll talk about in a little bit was environmental, had nothing to do with nuisance actions or negligence actions against fellow landowners. So to kind of sum up the torts portion of this presentation, what I'd like to say is, first of all, look at the contract. What does the contract say? If you signed a contract, that can have a big influence on what you can and can't do in a court of law. Other thing is, look and see what things are being contracted away. The right to bring a lawsuit might be one of them. The right to lease the land for hunting might be another one. You need to make sure, check these things out good before you do it. Other thing is, look at things like the ice throw, fire that may be caused, anything like that. What are some of the specific risks that you may have as an individual landowner, whether you've signed or whether you didn't? And try to address these concerns. A lot of times, a company will be pretty good to work with you. If you've got a lot of cattle out there, they're generally going to be good about, well, okay, let's see about either putting in a gate that will open and shut every time or putting in a cattle guard or doing something like that. Nobody likes to be sued. So, I mean, a lot of times you'll have people that will be willing to work with you. You just got to ask. Torts was part of it. The other part I'm going to talk about briefly, very briefly, is the environmental impacts. And we've got a lot of environmental laws across this country. The one I'm really going to focus in on is the Endangered Species Act, because this is one that could just kind of jump up and surprise people. Things they don't necessarily think about. As farmers, you know things like, well, you had the old swamp buster and sod buster provisions. You go out there and start filling in wetlands, they'll cut you back on or forbid you receiving farm program payments. Farmers are generally familiar with those type of provisions. Endangered Species Act is one, it kind of surprises people at times. And some of the things that are protected, you might not have ever seen or even considered it in the past. Things like the snail darter, minnows. I mean, there for a while, the bridge project out here on the South Canadian River was held up for a long time. I think it was a minnow, if I remember right, that was the holdup for that project. It was under this Endangered Species Act. Chances are, all of us has lived along that river, we've never seen one of those minnows. But it was a holdup for this project. So, talk a little bit about this, because it can kind of be a surprise. Right here, that was one of the surprises that kind of happened up there in the Woodward project, the lesser prairie chicken. Was it the blades themselves that was causing problems? No, not really. These birds don't fly very high or very well. But they get terrified by having things that are tall in the horizon. They don't want to roost. They don't want to lay eggs. Well, what can you do? The way these come up, specifically with the wind projects, anytime you've got a project that's going to be partially paid for by federal money, they have to conduct what's called an environmental impact statement. They've got to go out there and see, well, what are the potential things that we could do that might harm the environment, which includes those species that may be out there. Is there any way we can, or is there anything we can do that might mitigate some of those losses? Is there something we can do? Like, if we're worried about a lot of water running off and dirty water running off and polluting the streams, can we put things in there like filter strips and things to kind of clean up some of that water before it moves into the stream? When you're dealing with the Endangered Species Act, that can be a little bit difficult. The purpose of the Endangered Species Act is pretty simple. It's to protect endangered species. Fairly simple, fairly straightforward. You have a species that's either going to be listed as threatened or endangered. Threatened means, you know, if population trends continue the way they are, they're going to become endangered. Once they become endangered, get any more significant population loss, that species is going to become extinct. What they're doing is they're trying to prevent these species from becoming extinct. Once you lose them, you can't get them back. The people that are in charge of this are the U.S. Fish and Wildlife Service and the U.S. Marine and Fisheries Service. They will, once these species become endangered, these two federal agencies become involved. Now, before they reach the endangered process, they'll usually make a state agency in charge of the threatened species. But once it hits that endangered list, Fish and Wildlife becomes involved. We don't have to deal with a lot of fisheries issues around here. We're not really close to the ocean. But so it's Fish and Wildlife that we'd have to deal with this part of the country. They look at a couple of different factors. The one that's most important for today, though, the damage or destruction of a species habitat. Are you doing something out there that is damaging it or destroying that habitat? And what can they do to prevent these losses? When they look at the whole purpose of this act, like I said, it's to prevent the takings of these species. They're trying to preserve them. The definition of what the federal government considers a taking is extremely broad. Taking a 12-gauge shotgun out there and shooting it would definitely be considered a taking. And everyone could agree on that, right? You know, you go out there and shoot an endangered species, you've taken it, you've killed it, you've decreased the population. There's a lot of other things out there that go into that besides just shooting the animal. Harm can also include things like habitat modification. What's that mean? When you go out there and dist up ground, that is a habitat modification. If you're disting under native ground, or you're going out there and removing trees, or you're going out there and building barns, you're modifying the habitat. If there's an endangered species found there, you really need to be checking in to make sure that you can do what you think you can do with your property. In some ways, the Endangered Species Act can kind of act like an easement on your property. They can't force you to do anything, but they can force you to stop doing something that you want to do in the future. You may have to leave your land like it is right now. Cases, things like the spotted owl that was found in Oregon and Washington. You might have a great stand of timber that you want to harvest. But guess what? These owls are roosting in those trees. You may not be allowed to cut down your timber if they find an endangered species there. This lesser prairie chicken up there has got them kind of concerned. If anything over about 3.5, 4 foot tall scares this prairie chicken, well, what can you not do with your property? Well, how many of you people out there know of any barns that are shorter than 4 foot tall? I don't know of any barns that you can build that are shorter than 4 foot tall. What about a house? I guess you could do a dugout house, but so I mean, that's a lot of uses of your property that you may not have anymore. Not only does that affect wind development, it's also something that affects you as a landowner. So it's something you need to be aware of. Like I said, it's really easy to take these animals, and they may not be very big animals. Snail darters, the black-tailed prairie dogs, the ferret that feasted on the black-tailed prairie dogs. There's certain things out there you got to be really careful at. As Mike talked about earlier, he mentioned briefly, these things the wind turbines themselves haven't been that big of a deal when you're dealing with birds. And they haven't been. There's been a few cases in California where they had smaller turbines that the blades turned a whole lot faster, and those were a bit more of a danger for the birds. But the way these things are set up now, they haven't been that bad of an issue for birds. But evidently for bats, these things, it's a little bit more dangerous for the bats than it is for birds. This is where we've kind of seen the issues with endangered species really start coming out. Either from collisions or just from the barotrauma, just the change in pressure from those giant blades sweeping around. There was one case that I could find where a court did enter an injunction against a wind farm from operating, at least for a time. And what happened was, you got a large project, partially funded by federal money, so they had to do this environmental impact statement, right? Got to go out there and see what kind of environmental things are out there, what kind of endangered species are out there. They went out there and in the summer and said, well, looking around here, I don't see any endangered species. I think we're good to go. Let's build the project. The thing they didn't consider was migration. You may not have any endangered species out there in the summer, but during the spring and fall, they might be flying through there. And that was a problem they discovered out there. Guess what? Well, there was no bats out there in the summer. But in the spring and the fall, they were flying through there. And they weren't shutting off those turbines in the spring and fall, so they were causing bat mortality. And the court went in there and said, are you taking an endangered species? Yep, you're taking an endangered species. So that created a lot of problems for them in that one particular issue. Typically though, anytime they're doing these projects, like I said, these are multi-million-dollar projects, they're going to do a very good job going out there and doing the environmental impact statements. This is one where the developers they got a little bit sloppy. This is about the only example I could find where an injunction actually went through, and they held it for a while. The Endangered Species Act, though, it's a powerful piece of legislation. It's something that is not only is it an issue for the wind industry itself, it's something that it can be an issue for the landowners as well. And it's something you need to be aware of. A lot of times, you may have an endangered species on your place, you're not aware of it. No one else is aware of it. But when they go out there and put in these wind farms and they do this environmental impact statement, what they're doing is they're sending in people to start really looking, is there anything in here that is endangered? And they may find something in there that's endangered. So you as a landowner need to be aware of this as well. It could be an issue that pops up, and your use of your land, it may have to change, or may not be able to change in the future, to be a little bit more accurate. So it's something that landowners need to be they need to be concerned about. Are there other environmental issues? Absolutely. Clean Water Act, things like that. We just don't have enough time to get into that kind of stuff today. So does anyone have any questions? Yep. From what I heard, the question was, where are we standing at right now with this lesser prairie chicken? Well, right now, lesser prairie chicken's not that big of an issue right here. It's mainly north of here. When you're getting up towards Woodward, it's where you really start getting into their habitat. We heard from the gentleman from the Oklahoma Fish and Wildlife Service at one of our earlier workshops. And basically what he said was, they're really working very hard to keep that bird off the endangered species list. Because right now, it's kind of in the providence of Oklahoma Fish and Wildlife to deal with it. And they can do things like, we set up habitat over a couple of miles, and we'll set up a big habitat for breeding ground and try to recover the species there. Once it reaches the endangered status, though, it's kind of taken out of their hands, and it goes to the U.S. Fish and Wildlife Service. And then what they want to do, it may work well with what landowners want to do, and it may not work well with what landowners want to do. The ball's going to be in their court then. So right now what they're trying to do is, the ball's in the Oklahoma Fish and Wildlife Court, and they're trying to keep it out of the U.S. Fish and Wildlife Report. And it's all about, if they can show enough of these numbers so that it doesn't go on the endangered list. That's where they're at the moment. Yep. They are trying very hard.
Oklahoma, Colorado, Texas, and Kansas, they're all doing flights and so on.
They're all, I mean, as a state agency, you generally don't want to see this turned over. Because once it's turned over, you lose control over it, then the feds are coming in on it. So I mean, they're trying everything they can right now to keep it at the state level. I hadn't heard about the agreement with NRCS though. Okay, that may be why I haven't heard about it. I've been working on a couple other projects the last couple of weeks, so I haven't been keeping up with all of my reading.
How specific are the locations? Like if it's on this section, the next one, the next 10,
for endangered species, for a lot of this kind of stuff, what they've been looking at is, do you have the habitat? Is this the kind of habitat that this animal would like? They don't actually have to show that that particular species has ever been on your property. But they can show, hey, you've got a native grass on your land that's about knee high, and this is a perfect breeding ground for this particular species. The fact that you've never seen that species on your property, and neither has Oklahoma Fish and Wildlife or U.S. Fish and Wildlife, that doesn't matter. Is this the habitat? Is this in the range that we expect to find this species? And is your land suitable for it? And if it is, they'll go in, they'll map out the species. Like the lesser prairie chicken, it caught the southern part of Kansas right there and kind of ballooned down and kind of got western Oklahoma, a little tip of the panhandle, and it kind of trailed down and into a little bit of Texas. They map the species. It's not so much on a county level, it's are you in this designated zone where they think this, the habitat for that species is. So yeah, it's possible for one county to say, we've got it in this county, but another county they're saying, well, we're technically outside of their habitat on the maps that they send out, so we're okay. Any other questions? All right, with that being said, I'll turn this show over to Shannon and let him start covering the leasing aspect of it, which is probably a little bit more of what you guys are coming here for today. So, that being said,